record the session. You may be recording now, good, because the story and video will be posted on our YouTube site. As you know, I'm A.G. Harmon, and I'm going to welcome you on behalf of the faculty for zooming into the second of our presentations in this year's Student Scholar Series. I always say this, but the series was instituted, I don't know now, almost 12 years ago, to recognize notable legal scholarship produced by members of the student body during the previous academic year, and to foster the skills associated with presenting and defending that scholarship in a professional conference style setting. And today's presentation will be made by our third year student, Aimee Solano. So I'm going to introduce Aimee in just a minute, but first a few words about the respondent to her presentation, who has helped us in this way before. One of our favorites, Dan Zackham, who is a 1985 graduate of the Columbus School of Law. Following graduation from law school, he served as a judicial law clerk to the Honorable Frank Q. Nebaker, I hope I said that right, of the District of Columbia Court of Appeals. He then served for 2 years as a staff attorney at the United States Court of Appeals for the District of Columbia Circuit, and then worked for 22 years as an assistant United States attorney in Washington, D.C., where he litigated numerous cases in both the Superior Court for the District of Columbia, as well as the United States District Court for the District of Columbia. The last 10 years of his career at the U.S. Attorney's Office was spent as a supervisor in the homicide section. Then following that career in the U.S. Attorney's Office, he taught criminal procedure at American University before joining our adjunct faculty, where he was honored on numerous and multiple occasions as the evening professor and adjunct professor of the year for his classwork. And in 2019 was the outstanding part-time professor for professional schools at Catholic University. So obviously a long and distinguished career, and we're especially thankful for him coming back to doing this for us today. It's an honor to have him. I will now tell you a little bit about today's student scholar. Aimee Solano is a third year student from Southern California. She graduated from Mount St. Mary's University with a BA in political science and philosophy. She is a member of the Moot Court Association and an associate editor of the CUA Law Review. Throughout her time at Catholic, she's interned for both state and federal judges, worked for a government agency, and participated in the Low Income Taxpayer Clinic, and worked as a part-time law clerk at Kelly Gutso PLC, a consumer protection firm in Northern Virginia. As to what piqued her interest in the topic of today's talk, in the pre-COVID world, Aimee often traveled in and out of LAX, as she's from Southern California. So a circuit split regarding criminal prosecutions of crimes committed on planes interested her. While that split has been resolved now, she will be addressing its implications in her presentation. So what we'll do is turn the floor over to Aimee now for about a 20-minute talk and her presentation. Then we'll have the response with Dan Zackham, and then we'll open the floor up to Q&A. Just to ask everybody to keep yourself muted so there won't be any background noise. And then when we open up to Q&A, just to unmute yourself and go back on mute after you have asked your question. So now I'll turn the floor over to Aimee to present her work entitled Air Aware, Crimes in the Air and the Circuit Split That Could Change How and Where Air Crimes Are Prosecuted. Aimee.
Thank you, Professor Harmon. Can everybody see my screen? Okay, excellent. So as Professor Harmon said, my name is Aimee Solano. I'm a third year student. I wanted to take a moment to thank you all for coming to my presentation. It's been very rewarding to see my work and research come to fruition. I also wanted to give a special thank you to my family who's joining this presentation all the way from California. There are a few benefits to our virtual world, but being able to share a moment like this that would typically take place in person with family across the country is definitely one of them. Last but certainly not least, I wanted to thank Professor Zackham for serving as my expert reader during the research of this presentation and who will be serving as the respondent. I had the pleasure of having Professor Zackham my second year in criminal procedure, and it's been an absolute joy to work with him. So my presentation, Crimes in the Air, How and Where Air Crimes Are Prosecuted. In 2018, the FBI observed a spike in criminal activity and began an awareness campaign to increase both passenger awareness and to serve as a warning to assailants in an attempt to combat these increasing rates. The graphic on the slide right now was part of the FBI's Be Air Aware campaign. In addition to sexual assaults, a wide variety of other criminal activity is becoming more prevalent during flights. Stories of air rage, hate crimes, and sexual assault are prevalent on flights throughout the United States. What initially caught my attention with this circuit split were these troubling stories of harassment and abuse taking place at 30,000 feet, where there's often nowhere to turn. So when I heard that the Ninth Circuit, my home circuit, departed from the 10th and 11th circuits and holding a limited venue, I immediately knew what I wanted to do my research on. As the title of my paper suggests, my article explores a circuit split that was created by the Ninth Circuit's panel decision in the United States versus Lozoya in 2019, which challenged where crimes committed in airspace, specifically on a commercial aircraft, can be prosecuted. Before I get into the facts of the case and what caused the split, I want to make an important note, as Professor Harmon said at the beginning of this presentation, that since writing my article, the Ninth Circuit en banc reversed the panel decision since dissolving the circuit split. That being said, I think there's still a lot of value in understanding why the Ninth Circuit panel split and why the Ninth Circuit en banc reversed and became in line with the other circuits. As with any other case, the specific facts of this case are critical to the applicability of statutes, especially in a fast-paced case moving hundreds of miles a minute, like on an airplane. On July 19th, 2015, Lozoya and her boyfriend were flying home to California from Minneapolis. Their flight to Los Angeles was scheduled for about 3.5 hours, the route taking them over Minnesota, Iowa, Nebraska, through Colorado, Utah, Arizona, Nevada, and eventually into California. Lozoya was trying to sleep and claimed that the passenger behind her, Mr. Wolf, kept jabbing his touchscreen monitor attached to the back of her seat, and with every jab kept waking her up. In the middle of the flight, and there's a dispute as to exactly how far into the flight, Lozoya turned to Wolf, who was returning to his seat, and asked him to stop banging on the back of her seat. An argument ensued, and Lozoya slapped Wolf's face. Flight attendants immediately intervened, and shortly thereafter, the plane landed in LAX. Lozoya and Wolf went their separate ways, and it wasn't until later that Wolf reported the incident to the FBI, who issued Lozoya a violation notice, charging her with misdemeanor assault within the special aircraft jurisdiction of the United States. This is an approximate illustration of the path of Lozoya's flight, again, starting in Minnesota and ending through California. I think it's an important visual to show exactly how many states and federal districts were being crossed in this short amount of time. It's 8 states in 3.5 hours and even a handful more federal districts. Witnesses disagree exactly how long before landing the fight and eventually the slap happened, and 2 witnesses give an estimate that differ by an entire hour, which again, on a plane traveling hundreds of miles a minute, is very significant. Lozoya's criminal charge was misdemeanor assault within the special jurisdiction of the United States. So how did we end up in federal court? Lozoya's crime, it was a slap, an unauthorized touching, and this sort of offense conduct would ordinarily be tried in a state court under state laws, but this wasn't an ordinary slap. It occurred on an airplane, and there's specific federal statute that confers jurisdiction in federal court for offenses that occur on an airplane. 29 USC 465012 granted that special aircraft jurisdiction. Decades ago, on the onset of the age of aircraft, as it was called at the time, Congress recognized that crimes committed in the skies raise difficult questions. Although state criminal statutes generally cover crimes committed on board aircraft in flights over the states, in these high-speed, high-altitude flights in jet crafts, the issue of where venue is for purposes of prosecution can become complicated. Congress chose to federalize certain offenses committed on airplanes, including murder, sexual assault, and Lozoya's crime, a simple assault or a slap. When looking into venue, there's really 2 umbrellas that we're considering. The first is the constitutional framework for venue, and the second is venue is a statutory matter. Under the first umbrella, there's 2 locations that really consider criminal venue in the Constitution. The first is Article 3, and the second is the 6th Amendment. The second umbrella that we look to for venue is venue is a statutory matter, and there's two statutes that are discussed as possibly being applicable in this case. The first is 3237, which relates to continuing offenses and interstate commerce, and the second is 3238, which the concurrent and dissenting opinion cites, which I'll get to in a few slides from now. With respect to the first, venue is a constitutional matter. The Constitution safeguards a criminal defendant's rights in venue in two places. The first is the venue clause of Article 3, and the second is the Sixth Amendment's vicinage clause. Criminal venue was a really important matter for the framers. The Declaration of Independence criticized the Crown for transporting colonists beyond the seas to be tried. And the framers, because of this, designed a system that requires trial in the vicinity of a crime to secure the party accused from being dragged into some distant state away from their friends, witnesses, and neighborhood. The venue clause of Article 3, Section 2 provides the trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where said crimes shall have been committed. It's important to note that the actual language of Article 3 uses the required shall, not a permissive may or might, really emphasizing the importance that criminal venue had to the framers. The second safeguard for a criminal defendant's venue rights is located in the Sixth Amendment's vicinage clause, which further requires that the defendant be tried by an impartial jury of the state and district wherein the crime shall have been committed. Under these two provisions, criminal trials generally must take place in the same state and district where the crime took place. But if the crime was not committed within any state, then Congress may, by law, direct where the crime can be prosecuted. And the authority for this comes from Article 3, Section 2, Clause 3. Given the inadequacy of our usual interpretive tools, we should interpret the venue clause in a manner consistent with its evident purpose. A ruling that crimes are committed entirely in the navigable airspace are not committed and not committed within any state is consistent with that purpose because it allows Congress to identify reasonable places to hold trials for such crimes. The framers anticipated difficulties in determining venue, and although they never could have anticipated something like a flying vehicle moving hundreds of miles an hour, crossing the country in a matter of hours, they gave nod to the fact that location of a crime can be difficult to locate and planned a catch-all provision that empowered Congress to direct where the crimes shall be tried. Without this catch-all provision, the statute that follows, prosecutors would be required to establish where a criminal act occurred in airspace over a state, and defendants would have to be tried in that flyover state, which is the antithesis of the purpose of Article 3 in the Sixth Amendment. Congress did, in fact, enact a venue statute, 18 U.S.C. 3237, that's completely applicable in this case. In the Ninth Circuit's panel decision, which created the initial circuit split based on what Lozoya was arguing, Lozoya had argued that the Constitution requires trial in the district over which the plane was flying at the exact moment of the assault. Her argument essentially stated that her crime was committed in the airspace above a district, and so that district was the location of her crime. Implicit in her reasoning is an interpretation of Article 3 and the Sixth Amendment that a state or district includes the airspace above it for constitutional venue purposes. Lozoya was not tried in the flyover district, but in the Central District of California, where the plane landed and where she lived and worked. The Ninth Circuit panel decision agreed with this and was the basis of my research. The panel held that the venue was not proper in the Central District of California, stating that neither the two statutes that will be discussed later, 3237 nor 3238, applied, and that ultimately venue was limited by the constitutional constraints that must be where the crime was committed and looking down to the land below it. This decision was ultimately reversed en banc, and the Ninth Circuit en banc held that for crimes committed on planes in flight, the Constitution does not limit venue to the district directly below the airspace where the crime was committed, relying on Article 3, Section 2, Clause 3, that catch-all that stated that venue shall be at such place or places as Congress may by law have directed. An excerpt from the opinion is on the slide.
Hi, how are you?
The very purpose of the
Thank you
Constitution
so much.
provisions
Thank you.
to protect the criminal defendant from the unfairness and hardship to which trial in an environment alien to the accused exposes him is thwarted by limiting venue to a flyover district where the defendant may have never set foot. What continuously baffled me throughout this case was the argument made by Lozoya that she ought to be tried in a district outside of where she lived, which was likely less convenient for her. If Lozoya were successful, her crime doesn't go away. It would have simply been refiled in the flyover district. So I appreciated the en banc court recognizing the irony of Lozoya's own argument. After considering the constitutional basis for venue, we next turn to the statutory requirements for venue. 18 U.S.C. 3237 contains 2 paragraphs, each covering a different type of offense. The first is for continuing offenses, and the second is for offenses involving interstate commerce. The first paragraph, for offenses begun in one district and completed in another, states that, except as otherwise expressly provided by enactment of Congress, an offense against the United States begun in one district and completed in another, or committed in more than one district, may be inquired of and prosecuted in any district in which such offense was begun, continued, or completed. The factual predicate of this case is extremely important. Lozoya presents an interesting case because it was a discrete action that had a relatively swift start and end. It was a slap. It happens in just a matter of seconds. Contrasted with the true continuing offense, which happens, over a long duration of the flight. And the example that's best illustrative of a continuing offense that most people are familiar with is Flight 93 on September 11, 2001. The timeline of Flight 93, as most of us are aware, began at 8:42 a.m. when the plane left from Newark, New Jersey, headed to San Francisco, California. At 9:28 a.m., the hijacking began, and from 9:30 to 9:53, there's multiple phone calls and text messages marking the continued air piracy, leading until at 10:03 a.m. when Flight 93 crashed into Stony Creek, Pennsylvania. The plane was on its path for 46 minutes after takeoff before the hijackers stormed the aircraft, and 9 minutes later turned around and began a new course. The crime, in this case, air piracy, was a continued offense. It began at 9:28 a.m. and continued to the plane's crash at 10:03 a.m. During that time, the route traveled through 3 states and over multiple federal districts. The crime was a continued offense that occurred while passing over multiple states and districts. This is contrasted with Lozoya's crime, which was a simple assault and a singular slap. So instead of relying on the first paragraph of the statute, the court en banc relied on the second paragraph relating to interstate commerce. The second paragraph relating to interstate commerce states that any offense involving the use of mails, transportation in interstate or foreign commerce, or the importation of an object or persons into the United States is a continuing offense, and except as otherwise expressly provided by enactment of Congress, may be inquired of and prosecuted in any district from, through, or onto which such commerce, mail matter, or imported object or person moves. Both the 10th and 11th circuits have held that the second paragraph of 1337A applies to in-flight crimes because the crimes took place on a form of transportation in interstate commerce. 2 cases, United States versus Brett Weiser and United States versus Cope, considered where criminal charges should be brought against a defendant who committed the crimes in airspace. In both these cases, the court upheld venue in the district where the airplane landed, rather than requiring the government to show exactly which federal district was beneath the plane when the defendant committed the crimes. The 9th Circuit eventually joined the 10th and 11th circuits in holding the second paragraph of 3237 to apply to Lozoya's crime as well, holding that her crime involved the transportation of interstate commerce, using the plain meaning of the word involve, meaning to relate or affect. Not only did Lozoya's crime take place on a form of interstate commerce, but the assault is a federal offense only because it was committed within the special aircraft jurisdiction of the United States. But for interstate transportation, Lozoya could not have committed this specific offense. And an offense whose very definition requires interstate transportation certainly involves transportation in interstate commerce. Even in the en banc decision, there was a partial dissent and partial concurrence. The partial concurrence came to the same conclusion that reversed the panel decision and held that venue was proper in the landing district, but dissented, arguing that the majority applied the wrong venue statute. The concurrence believed that 18 U.S.C. 3238 it was proper for trial on assault for cross-country flight, limiting that charges could only be brought where the defendant was arrested or first brought and where the defendant resides. However, this statute relied on by the dissent and partial concurrence is inapplicable in this matter. The statute that they're citing relates to crimes that occur on the high sea and is meant for crimes that have taken place outside of the United States, which is not the case here. However, even the partial dissent and partial concurrence came to the same conclusion that venue where Lozoya resides and was arrested was proper. Aside from statutory and constitutional matters, there's public policy and common sense reasons to relate back to the Ninth Circuit's en banc decision. Venue in the landing district is plainly sensible. It's the destination and it's where most of the facts, like things like interviewing a witness and the initial charges might happen. There's examples of landing district venue in every circuit except for the DC circuit, and that's because the District of Columbia has no commercial airports. And no court has prohibited venue in the landing districts where arrests are made and witnesses are interviewed, since it is often either the defendant's residence or travel location. It simply defies common sense to confine venue to a flyover jurisdiction where it's possible that neither the defendant nor witnesses nor victim has ever stepped foot. Following Lozoya's reasoning, we would now impose on the government the additional burdens and costs and delays associated with an inconvenient venue. Not only is Lozoya's argument nonsensical, it's also a dangerous argument. Flyover prosecution is virtually unheard of for good reason. To establish venue under Lozoya's theory, the government must determine exactly when the crime was committed, use flight tracking sources to pinpoint the plane's longitude and latitude at that precise moment, and then look down 5 miles to see which district lay below. Even in this case, witnesses gave different estimates of when the slap occurred. Lozoya's flight was from Minneapolis to Los Angeles and crossed at least 8 districts in 3.5 hours. In the span of a single hour, which again is the difference between the estimates of only 2 witnesses, an airplane can easily fly over multiple states and districts. A flyover venue rule would unreasonably burden victims of in-flight crimes and the interests of justice, and of particular concerns are victims of sexual assault. According to the FBI, reports of sexual assault on commercial flights are at an all-time high. Sexual assaults are most common on long-haul flights when the victim is sleeping and covered by a blanket or a jacket. Sometimes there are no witnesses. Victims report waking up disoriented and realizing the horror that they were assaulted by a seatmate. Proving the precise time of an assault could be impossible, and a flyover venue rule could mean no prosecution at all. A case that best illustrates this is an 11th Circuit decision in the United States versus Brett Weiser. Brett Weiser involved the sexual contact and assault with a minor on a flight from Texas to Georgia. The facts of Brett Weiser show the chilling possibility of a circumstance where justice could have been circumvented by the need to locate the precise location of an assault. In that case, the minor was a 12-year-old girl, and she did not immediately seek help. It wasn't until another passenger intervened that the girl and her sister admitted their discomfort by the defendant. If the girls had to pinpoint the precise time of the assault, the government might not have been able to prosecute the case for failing to allege by a preponderance of the evidence where venue was proper. It is precisely cases like Brett Weiser that illustrate the practical concerns with a strict regulation of venue. If the court in Brett Weiser applied the standards established in the panel decision in Lozoya, it's possible that this case could have been dismissed. Fortunately, the Ninth Circuit reviewed their panel, en banc reviewed their panel decision and reversed. On December 3rd, 2020, the Ninth Circuit reviewed the panel decision en banc and reversed the panel decision, eliminating the circuit split and holding that the Constitution does not limit venue for in-flight federal crimes to the district sitting directly below a plane at the moment the crime was committed. Such in-flight crimes are covered by 18 USC 3237 and may be prosecuted in the flight's landing district. Thank you, and I would like to turn the floor back to Professor Harmon.
Thank you, Aimee. Now I will turn everything over to Dan Zackham to conduct about a 10-minute conversation with Aimee and solicit her responses to questions he might have. Dan.
Thank you, everyone, and it's nice to see everybody. A couple of points at the outset. First, Aimee deserves a great deal of credit, obviously, for not only a wonderful presentation and a well-written article, but she called this months ago. When we first started discussing her article, I believe it was like last summer, the Ninth Circuit panel decision was out there, and it was obviously good law in the Ninth Circuit in creating the split that Aimee has referred to. But she called it. She called it not only as a common sense matter, but also predicted many of the points of law that when the en banc court came to their senses just before Christmas, they agreed largely with Aimee's analysis. So I think she deserves a great deal of credit for that, obviously. And also, I'd also like to point out that I have to confess that when Aimee first brought the topic to my attention, we first began to discuss it, I was bored to tears. I've gone to court, I don't know how many times in the course of my career, and not once, not ever had I been forced to think about venue. It's something that we take for granted, right? We walk into court and it's only the extraordinary case where a defendant is going to reasonably be able to claim that the location of the litigation of the matter should take place in a jurisdiction other than the one in which he or she was charged. So I was kind of like, oh my goodness, what's the point of talking about venue? And then I became sensitized to the idea, as I hope everyone here is, that there really is a problem, and especially with, as Aimee concluded, with regard to sexual assault charges and those involving children. So this is a real issue. It's not a made up academic exercise to talk about a discrete legal issue that has no practical application. It's far from it. And I wanted to just thank Aimee for educating me and further sensitizing me to an issue that is indeed real and not just a academic exercise that we're going through. Having said that, Aimee, I've got a couple of questions. You pointed out at the outset that there are, we begin, as we always do, with the federal constitutional predicates for the issue here. And is it not true that the Constitution is very clear that venue shall lie in the state in which the crime, state or district in which the crime is committed, or wherein the crime is alleged to have been committed? If that is true, and if we begin our statutory and constitutional construction with the plain language of the document, can we say that Lozoya's conduct happened as a factual matter in California, or wherein California, as those terms are literally understood?
Relating back to the constitutional provisions and considering both Article 3 and the Sixth Amendment, it specifically provided for a catch-all, sort of punting the question back to Congress and stating that where crimes are difficult to be located and where you can't find that precise location, Congress shall dictate where those crimes can be prosecuted. And in this case, Congress did precisely that through 3237. So I would say that the Constitution is entirely satisfied because they provided for that clause in Section 2, stating that Congress can decide for those specific circumstances. And here, to the statute, Congress did precisely that and stated that for continuing offenses or interstate commerce, like what happened in Lozoya, venue shall be proper wherein at any time that crime continued or ended.
So the framers here, unlike so many other questions of constitutional interpretation, where we're kind of lost as to what the framers' intent might have been. Is it fair to say that here the framers left us a very clear clue and foresaw, while they were not able to foresee air travel as a specific mode of transportation in the future, they were certainly able to foresee and did foresee that there might be venue questions generally that arise, and provided for that within the document itself. Is that fair to say?
Yes, exactly. Although this wasn't anything they could have anticipated, they specifically did anticipate problems, which gets us to the statute today.
And with regard to the statute, if we look at the first paragraph of 3237, and we talk about continuing offenses, and you did a wonderful job of, as a factual matter, distinguishing between a continuing offense as a factual matter, such as an act of air piracy, from the discrete act here. So we could pretty easily conclude as a factual matter that the conduct alleged here is not a continuing offense, as that term would properly be understood in the statute. Is that what we're saying? In the first paragraph of the statute?
Yeah, in the first paragraph alone, this probably wouldn't satisfy the statute, but using typical statutory interpretation rules and purpose inferred from, providing a second paragraph to a statute, we can assume that it should be read in conjunction. And although this offense probably wouldn't survive paragraph 1 standalone, it does survive paragraph 2 read in conjunction with paragraph 1.
Paragraph, isn't it true, or tell me if I'm wrong, that paragraph 2 provides just another pathway to get to continuing offense? Am I reading that accurately?
Yes, it specifically states that interstate commerce relates back to continuing offense and then gives the jurisdictional provisions for that.
But for an offense to qualify as a continuing offense under paragraph 2, it has to involve interstate commerce. Isn't that right?
Yes.
Okay. If you're Lozoya's lawyer, wouldn't you have a great deal of a problem with your client is charged with an act of simple assault, an unauthorized touching of another or putting another in fear through physical contact? How in the world does that reasonably involve the Commerce Clause?
Perhaps a typical assault happening, in any given state wouldn't involve the Commerce Clause, but Lozoya's crime wasn't just a simple assault. It was an assault that occurred on an airplane, which is per se a part of interstate commerce. When the court considered the second paragraph and looking into the Commerce Clause and how interstate commerce relates to this case, the court considered two things: both that the crime would be impossible without invoking interstate commerce. The charge that Lozoya was eventually charged with wasn't just an assault, but an assault that occurred while on an aircraft. And per se, Lozoya couldn't have been charged with that offense without invoking interstate commerce. And secondly, this crime, again, was only made possible through interstate commerce. If Lozoya wasn't on a plane, she wouldn't have been able to be charged with a specific offense.
I can imagine, can you, an argument that Lozoya can make in terms of just bootstrapping, that the federal government takes an offense that otherwise would be a violation of state code and then federalizes that offense, thus depriving the defendant of her constitutional right to be tried in the district in which the crime committed. Does that argument fly at all with you? That it's an overcharging by the federal government to not only federalize an offense, but also to rob the defendant of her constitutional rights under the venue clause?
So I think there's really two things there. There's the concern that, this overarches the constitutional protections that are specifically there for a person. And then the second concern of, just sort of strapping everything to interstate commerce, sort of like the constitutional law case that we all learned, Wickard versus Filburn, and making everything relate to interstate commerce. And with respect to the first issue, I don't find that this is that this violates the Constitution, sort of relating back to our first discussion, saying that the framers specifically intended for scenarios where the location of the crime is difficult to determine. And I don't think it's an overstep of Congress to say that in scenarios where we're moving hundreds of miles a minute and flying over states and federal districts, that it is proper to say that there's specific considerations for not having to locate the precise location of a criminal activity. And I don't think that that violates the constitutional rights. I think it goes perfectly hand in hand with the provision that the framer set out for scenarios where it's difficult to determine the location of a crime. And with
I'm sorry, and just following up on that point, isn't it also fair to say that congressional intent in passing 3237 and in taking, if you will, an expansive view of venue was their demonstrable intent in doing so because of the fear you pointed out at the outset that there were crimes at the time of the passage of 3237 that were literally going unprosecuted because of the government's inability to determine venue in these circumstances. Is that fair?
Yes, exactly. And without providing for a venue statute like this, goes against, our goals of justice and being able to prosecute crimes properly.
And just on a concluding point, well, what is the purpose of venue, just generally speaking? What's the whole point?
Relating to a constitutional sense, the purpose of venue was to limit the place where a person can reasonably be tried. Going back to as far as the Declaration of Independence, noting that colonists were being hauled across the seas and tried in front of King George for offenses. And the venue provision of the Constitution was explicitly created to avoid those scenarios where a person is being dragged away from witnesses, from their own locations, home locations, to be tried in some foreign state away from really anybody that could testify on their behalf or help them prove their case. So when we're looking at venue, we're really looking at considerations for the defendant's specific rights and sheltering those from unreasonable or unburdensome. Those should be viewed in conjunction with states' goals, and I think they do go together. What we're looking here to service is both the defendant's rights in not being hauled into some faraway court that's unrelated to the crime, but also the burden that we're putting on the government in the production of evidence in order to prosecute the crime.
And so, as you pointed out, so ironically, Ms. Lozoya, at least in front of the circuit, successfully argued to take the case out of her home state of jurisdiction, where at least some, if not all of the witnesses reside, and because she wanted to get into a van apparently and drive to Kansas City and have the case tried there.
Exactly. And it's very ironic that she was arguing that, just because not only was it where the plane landed, but it was her home residence. And it's likely where any witnesses that would have testified on her behalf would have been. And so her attempt to move it to a faraway district would have been inconvenient to her own argument and to the presentation of her own case.
Hence your life and future as a lawyer. All right, thank you, Aimee, for just a wonderful presentation. It was a joy to work with you, and thank you again so much for educating me and sensitizing me to an issue that I was not sufficiently aware of before your research. Well done. Thank you.
Thank you.
Thank you, Aimee and Dan, for a great presentation. I'm going to open it up to Q&A now for the balance of the time. I'm going to exercise my prerogative just to follow up on that last point that Dan made. And what possibly was her strategy in doing this? Was she hoping to frustrate and delay, as what was seemed to be the tactic in the child abuse case, to make this, I mean, was that their idea, is to make this the idea that you have to pinpoint where this occurred or you can't prosecute me, that kind of thing? And so that so was that was the strategy? And then just as a second point, is the effect of what's happened now after the resolution of this, that these things are going to be tried where you land? So it's a 2-point question, but first of all, what are your ideas as to the strategy point? And then the second, what is the effect of all this?
With respect to the first question, I think Lozoya's her ideal outcome was probably that it wouldn't have been refiled in the flyover district, although it could have been. She was likely hopeful that the case would go away, although that's not necessarily what could happen. It could very possibly be refiled in a more inconvenient venue for her, or it was just a fight for her belief that the Constitution provided that she had to be tried in the flyover state, specifically where the crime occurred. But with respect to your second question, I'm sorry, can you restate your second question?
I was just wondering, is the effect of all this, the resolution of the circuit split, that now most of these things are going to happen where you land? I mean, that's going to be where we're going to have this thing prosecuted, or is there any, is that the likely outcome of this, or what do you think there?
So that's the likely outcome, but that's not the only outcome. What's an important distinction between what the opinion of the en banc court and the concurring opinion was, we're applying two different statutes, 3237 and 3238. And the difference between those is that the concurrence was arguing for a statute that would only allow the trials to occur in the landing district. But the overall, the opinion held for a statute that simply permitted the trial of charges in the landing district. But I do agree that it is the likely outcome that these crimes will be prosecuted in the landing districts, simply because that's what a majority of other circuits do, as well as it's the most likely just because that's where often defendants are arrested and where witnesses are interviewed and where a lot of the people either reside or are staying at the moment.
I see. Makes sense to me. Questions? Anybody? If you raise your hand, we'll just recognize in order. Anybody have a question? Rachel, I saw your hand first, and then we'll go to Steve Young. Rachel Semino.
Great. Thank you, Aimee, for a great presentation. My question has to do with whether or not in your research, or just if you have an opinion about situations where maybe it's not as like where the destination where the plane arrived might not have been where they initially anticipated landing. So if there's like a redirection or an emergency landing, I can just see in situations like that, parties not necessarily anticipating to land in a certain state if circumstances changed, whether it's weather or just sort of other situations. I don't know if you came across this in your research, or if you just could sort of justify why this logic still sort of matches up with sort of extraneous situations like that.
Yeah, thank you for the question. For flights that might be redirected either due to weather or even due to the criminal activity itself, while I didn't come across any specific case law that discussed these scenarios, I think the same general principles are still applicable, because at the end of the day, that's where either the defendant is going to be arrested, where the witnesses are interviewed, and those same principles apply, even if it wasn't necessarily where the defendant, intended to land or where the witnesses live, as that might have been, and if the course had took its initial route.
Steve Young, question.
Yeah, great presentation, Aimee. Really enjoyed it. But I did have a question. To what extent would it change matters if this had occurred on a foreign carrier? So let's say we have a flight, a Lufthansa flight from Frankfurt to Minneapolis. The slap we know occurred over US airspace. So it still occurred in the US. But does it change things at all that it's on a foreign carrier?
That's a great question, and the scope of my research didn't exactly go into foreign territory. I think that's a really interesting question and important in terms of a conflicts question of, whose jurisdiction applies. But I would think that the same general principles apply insofar as it's landing in the United States. If it were the reverse and we have a plane leaving Minneapolis and going into Germany, that's certainly outside the scope of my research, but I think it's, very worthy of meriting further research.
Dan, do you have any thoughts on that too, to add what Aimee said?
Yeah, I think that Aimee's her gut instinct is correct. That while we would have potentially issues of international law and jurisdictional issues, if there was a question whether or not the criminal conduct took place within U.S. airspace, putting that aside, if we establish as a factual predicate that it occurs in U.S. airspace, and then we're just dealing with the inconvenience of prosecuting the case in Munich or whatnot, I think then what the Ninth Circuit does by joining the other circuits and saying, look, we can be flexible as to where venue is going to lie. The Ninth Circuit panel opinion said it had to take place in the overflight district, that the overflight district in which the crime occurred had to be the place where venue was located. The virtue of the Ninth Circuit joining the 10th and 11th circuits is, well, we can have some flexibility here, and we'll go back to our general principles with regard to what underlies the purpose of venue to begin with, which, as Aimee pointed out, cost and inconvenience to the government, ease of prosecution, where the witnesses are, where the defendants are, and so forth. If we're talking about United States citizens in a crime that was committed in US airspace, I can easily imagine a court saying that the departure district is going to be the proper place to hold venue in that circumstance.
Stuart, you had a question?
Thanks, AG. Thanks, Aimee. This is really great. My question is, what if the crime, say, what if Lozano was sold a cigarette, say, to a 19-year-old on the flight, and in California, the age to do that was say 21, but in Nevada, the minimum age was 18. Mm-hmm. And it takes place on the flight. So where do you go with that? So it's not, like Lozano would want to, it's not a crime in Nevada, but it is in California, and she's landing in California.
Thank you. That's a great question. I think this is where 3237 as opposed to 3238 becomes really important, because the venue statute applied in this case didn't limit the trial to only the landing district, as in this scenario where it wouldn't have been a crime, but permitted it through interstate commerce, where the crime continued through and ended. So in this scenario, it would be very possible that the defendant would be charged in, say, Nevada, where it was a crime, but not in California, where it was perfectly legal.
If I could also add as well, I mean, Stuart's question is a good one. It points out, where my thought process at the outset of speaking to Aimee about the case with regard to crimes that would otherwise be considered to be state offenses, such as the simple assault here, and what Congress chose to do with a number of offenses is to federalize them. So in Aimee's case, you have what otherwise would be a state offense that was federalized, thus providing jurisdiction to the United States district courts, and then venue decided appropriately thereafter. Stuart's question is a great one. If the offense is wholly state in nature, but it doesn't fall within the category of cases that Congress has chosen to federalize, that does pose a very, very interesting question. If the claim is, well, the offense took place in the airspace immediately over Nevada, where it was an offense to begin with, the only offense you can charge me with is a state offense because it hasn't been federalized. Therefore, it wasn't a crime at all, and venue almost becomes moot because there's nothing to charge me with. Fascinating question.
Any other questions right now? Again, we would normally, do this, continue this in the atrium, or we would have it over lunch and finish things that way. So perhaps Aimee will deign to answer your questions by email or something later. If not, still in all, a wonderful presentation, Aimee. Thank you very much for this, and Dan for your contribution. It was a fascinating thing, and again, something that's provocative, some things we haven't seen before, and we've been doing this a while, and I haven't seen this question before, so it was original and a great contribution. So thank you. We will send you a plaque in the mail because we can't see you right now. But anyway, or you can pick it up. And we will meet again on, March the 18th for the last of this year's presentations by Mark Noble. So if you can, please join us. We will have a story on this, and the recording will be on YouTube. So to honor the day. Thank you all for joining us. And again, thank you, Aimee and Dan, and we'll see you next month.
Thank you all.